Oh, what are we cheersing to today?
Life.
So many things.
Life.
First day of trial. Excitement.
Trying to get down to the truth.
Yeah. But we just finished an application, and I'm going to have a drink too before I get into this.
Yeah, so give a title to this episode.
I will, because this is a recurrent theme in our pre-trial applications. This is before we even get to trial. I'm going to call this the dirty words of sex assault trials. So there's a couple of things that keep coming up when we're asking to use evidence, which is what these applications are for, that we need permission from the court to use evidence, especially if it's of a sexual nature. And so for a long time, the phrase common sense has been like a dirty word, right? And you can almost see judges cringe when you mention common sense. But lately, the focus is saying we're not permitted to use evidence on the basis that it will give context to a narrative. Context and narrative are apparently no-no words, including just solely, you're trying to challenge the credibility of the complainant, which of course we are. That's the point of a trial. But so these things, there's a reason why we're being told we're not permitted to do this, but it's, from the case law, a misinterpretation of what was said. And we were actually told that context and narrative is dead since a case called Goldfinch.
Okay, so let's frame this for everybody. So Diana and I were recently in an application where one of the submissions for the lawyer for the complainant had specifically made the submission that context is dead. Narrative is a clever way of trying to get in context. It's dead since Goldfinch, which sparked Diana to get up and walk out of the room.
I think you told me I had to leave, actually, because I was getting so verklempt.
You were getting riled up. I said, calm. And I actually somehow remained calm. And to review for everybody, and this is a bit of a review because we've talked about this throughout a number of podcasts, and we don't want to be overly repetitive, but it's important to emphasize this because it's so incredibly disturbing that these submissions are being made, and we're seeing more and more these arguments being made by Crown attorneys and their factums. So again, just to regroup everybody, in a sexual assault trial where there is some relationship between the accused and the complainant, so our client and a complainant, and we want to bring an application to ask certain questions about prior sexual history and or about certain documents that we have in our possession.
That we're now forced to bring applications to use, even if they're benign.
Right, so they could be text messages or emails or even pictures. Any document that we're required now by the
a
case.
Receipt.
Everything.
Yeah.
It's a good point. By Regina versus JJ, Supreme Court of Canada decision, anything, no matter how innocuous, we have no choice but to bring this application. So we're doing it. And so in a recent application, there was these arguments made, which was very disturbing. And I mean disturbing in the true sense of the word disturbing. Yeah. And carry on from there. We
should point out first, too, that this is important because people come in here saying, how come you can't just get my charges withdrawn? Right? They don't. There's like, how is this going to trial? There's no evidence. And it's like, the reality is if you think you have evidence, you're going to have to jump through hoop after hoop after hoop. And it's now a process that, it's an access to justice thing too, because this is all at expense of the accused. And we're now forced to bring these applications. And the applications will require an affidavit, so they better be prepared to tell their side of the story.
Again, another good point. So, whoever is watching this podcast, if these are people who've been through the system and have been aggrieved and had this horrific experience, if you're a lawyer, or if you're potentially looking at our firm to help defend you, and this isn't a promotional thing, but people come to us and they go like, how can this happen? Why is this so cumbersome? And why is this so expensive?
And why is it going to take so long?
Because there's a lot of work involved, because the law has been made so incredibly complex that we have to bring these motions. And an access to justice issue is very much at the core of it, because not every human being can afford to defend themselves. Even when we give a break to people, we don't even charge for every single hour we put into drafting. It is incredibly complex. And as you're going to learn as we talk about this, because there's an appellate case that's scaring the hell out of you,
yes,
that's going to go to Supreme Court of Canada. And it emphasizes how if you're going to advance one of these applications, you better be prepared to lay out in your application and the affidavit of your client
in detail
what your defense is in very complete, comprehensive, coherent detail, everything. And if you think it's something where you want to hold something back, you may lose your application.
And one of the things that's helpful is that we actually publish a newsletter every 2 months, sometimes a little bit late. This is sort of an advanced version of...
We're late. This is supposed to come out for October, but it's a lot of writing right now.
And so we were looking into, and when we check for all the new decisions of import that come out every month. And so this one actually is called Is Context and Narrative Dead Since Goldfinch?
Yeah, so this is our first topic. So what was terrifying was that the argument is simply this. The Crown and the lawyer for the complainant will say, any evidence that we have that we want to advance at trial or cross-examine on, other than the subject matter, other than what happened at the moment that the sex assault is alleged to have occurred, is presumptively inadmissible.
Yeah, so it could be like a weekend of, drug-fueled sex going on, but only one of the occasions is alleged to be non-consensual. So apparently you can't talk about the fact that there was other sex going on throughout the entire weekend leading up to an incident.
Or even worse than that. So let's say these people have a relationship, and there's, on this particular day, there's an alleged sexual assault. We're not allowed to talk about their relationship unless we bring this application. You may think, well, wouldn't that be natural to have some sort of context to understand who these people are, how they relate to each other? How did this come out of this relationship? Well, we have to ask permission of the court, and we have to seek, leave of the court to prove that this is probative.
Mm-hmm. And Goldfinch, interestingly enough, was a case where the sole item of concern was that he was permitted to say that their relationship was that after having dated before and broken up, they became friends with benefits.
Right.
And the phrase "friends with benefits" was obviously implies some sexual activity. And so as a result, they decided that he actually should not have been permitted to have that evidence go in, mostly because his application was deficient.
Explain that a little bit more slowly so everybody gets it, because we've tried to do this before, but this has incredible education value. And we have, God bless, we have viewers from Ireland, criminal lawyer in Ireland, people in Australia and other jurisdictions who are comparing their circumstances and their legal principles to ours. So this is and we get great comments and feedback because it's really good to understand what's happening in other jurisdictions. So just explain this a little bit more.
So these applications are so important that, one, if you don't do them correctly, you could be denied evidence that's important to present your version of events. But second of all, if you should have been allowed, and I've come across a few cases like this now on appeals, if you have to appeal a conviction and you're saying that one of the problems was that you should have been permitted the evidence, I have seen it be determined that the evidence may have been relevant, but it has to be based on the application, and the application did not define the purpose they wanted well enough. Therefore, the application was properly denied. So even though it could have been a different trial and that evidence may have been relevant, a failure to conduct these applications properly
and properly articulate all of the ways in which the facts are grounded in the evidence and how it's relevant.
Right. Then it'll be seen as not having, basically being deficient, not having provided all of the proper context to the purposes that you wanted to use the evidence.
So on appeal, you lose. Yeah. And so the idea is that on appeal, and this is typically a term in appeal, you can't amplify the record by further submissions as to what should have been stated at the time of the application. We don't agree with that, and there are other jurists in appellate courts to the opposite opinion that you can actually amplify because there are oral submissions in an application, and so you can give other reasons and you can take a look at it holistically. But there's a lot of cases that say if you didn't get it right the first time, you're f***ed on appeal.
So if we look at what was actually said in Goldfinch, did you have Goldfinch in front of you right now?
Oh, yeah.
Okay, so the thing that they're quoting is actually from paragraph 5, I believe, where they say that a bare assertion that evidence will be related to, will give context, narrative, or go to credibility. A bare assertion that that's the import of it and the purpose for it will not be sufficient to be granted the ability to use the evidence. And so this...
So let me read that for a second. Yeah. So...
Am I right? Paragraph 5?
Yeah, you're bang on. So... Section 276 requires an accused to positively identify a use of the proposed evidence that does not invoke twin myth reasoning. In other words, relevance...
We should explain that just briefly.
It's explain twin myth reasoning,
Yeah,
not
because-
multi-myth reasoning.
Yeah. So twin myths is basically the same evidence used for two improper purposes. So evidence that a woman has had sexual activity, or a male complainant, whatever, that there has been sexual activity in a previous time frame, makes them more likely to have consented to the sex in question, and makes them less worthy of belief because they're not pure. They're not a virgin of some sort.
And these are clear myths which we know and have understood for well over 2 decades. No doubt about that. So the court goes on to say, in other words, relevance is the key which unlocks the evidentiary bar, allowing a judge to consider the 276 factors, so the factors that set out in our criminal code, and to decide whether to admit the evidence is to be guided by these specific factors. Importantly, what you said, bare assertions that such evidence will be relevant to context, narrative, or credibility cannot satisfy Section 276. The evidence in this case should not have been admitted and a new trial is required. Done. Bare assertions that such evidence will be relevant to context, narrative, and credibility cannot satisfy 276. That is the bar. That is the bar to the admission of this evidence. That's the bar. So when there is these arguments made that all this type of evidence is not admissible to context, narrative, or credibility, or in other
And
words...
they turn those into dirty words. Like if you use the word context or narrative, then all of a sudden it's just like, oh, we know you can't do that.
Right, but this is where we meet with this argument that context and narrative is dead. That's absolutely an inaccurate analysis of the case law. Even Goldfinch, and we're going to take you back a little bit with the history of this legislation, but even this case from the Supreme Court of Canada simply says that bare assertions such as bare assertions relevant to context, narrative, or credibility cannot... That's just saying, I want to use this evidence.
Mm-hmm. I've got a sex tape of me and this person having sex, and it's going to be relevant for narrative and context. But you don't say why.
You're not describing why. You're not grounding it in evidence. You're not explaining how it's relevant to an issue in the case. That's a bare assertion.
One of my pet peeves that we see from Crown sometimes in their responses as well is that they forget that there are two versions of events that the evidence can be relevant to. It's not just what the complainant said and whether or not the evidence will contradict the complainant on something. It can also be relevant to support the version of events that we say we anticipate are the accused will be giving.
Yeah, they like to forget, and I believe really hamstring an accused that they can only testify about a narrow set of facts. And that's just not simply true. There are fundamental rules about what a client should be able to testify to in a sexual assault case, but they want to construe it in a way where really you can only talk about what informs consent at the time of the offense. That is the bullshit that we face in so many of these applications. How is this evidence relevant to the issue of consent at the time of the alleged sexual assault? And that is not always the only issue, because a central issue in a criminal trial and a sexual assault trial is, oh my gosh, credibility.
Right. It is almost always the central issue. And there's a reason why they call these he said, she said cases, because there's two versions of events. But one of the phrases that we've come across with one district in particular is they say there's no air of reality to what the defense proposes they're going to say at trial because the complainant said this. Therefore, there's no air of reality to a different version of events.
Right, and that's just poppycock.
And what do I
there is
constantly...
there is absolutely, let's be clear on this. There is no rule of law that in order for a client to testify about his or her version of events, that there has to be an air of reality to it. That's just bullshit.
That's something for trial to be determined, really.
No, but to testify to say, this is what happened at the time that we were together and leading up to it, that there has to be an error reality to it, is inaccurate. That applies to another type of defense, not to your explanation as to what happened. But they love...
Yeah. But, to say that I remember seeing the first time this argument that the defense is not permitted to attack the complainant's credibility, using evidence on that they're seeking on this application. That I was like, how did they even get there? That you can't go after somebody's credibility, and I ended up expressing it something like, the fact that their credibility will be affected by the evidence is a consequence, not the actual purpose. The purpose of the evidence is to get at the truth of what happened.
Right. So if we go back in time, and you're absolutely correct, to cases like Seaboyer, which is the first challenge to the first iteration of the 276 regime to prevent certain questioning about prior sexual history, to cases like Regina versus Oselin, and then to the case of Derek. Mm-hmm. Every single one of these cases refers to credibility as being a central issue in all trials, including sexual assault trials. And relevant probative cross-examination is allowed. Like, these are Supreme Court of Canada decisions which are not overturned by Goldfinch or some mythical reasoning by some future Crown attorney or lawyer for a complainant. Credibility is very much at play in a sexual assault case. Period.
Mm-hmm. Oh, I know. There's massive case law that all says the same thing, but the problem is these inconvenient phrasings when you isolate them from the rest of the decision, because, in Goldfinch, there's a lot of things that support allowing evidence for certain purposes. I mean, we were going through it earlier today again, and they say where a complainant denies the existence of a relationship, it will make evidence relevant.
So talk about that for a second. Let's say you have a scenario where the accused and the complainant have dated for about 4 or 5 months, and there's an allegation of sexual assault, but the complainant in her testimony states, and I'm just saying her because we can have a male complainant or a female complainant, but we're using an example we know of. And the complainant says, up until the point that this sex assault occurred, we were purely platonic. We did not have any intimacy whatsoever. We were just friends. Mm-hmm. So that casts the relationship in a certain narrative. In other words, it says, it could actually say the complainant saying, I would never have had sex because we didn't even hold hands or kiss before this particular incident. We were just friends. So that's a narrative that the complainant describes leading up to the actual sexual assault. That's f***ing allowed by the prosecution.
Not only allowed, but it's elicited by the prosecution. So when they have their complainants sit down to start testifying, they say, so tell me about what happened and how you got there. That's narrative.
Right.
That's context.
So it's allowed for them.
Right.
Right. And they're trying to say it's not allowed for us. So now let's say your client says, oh, hold on. We'd been dating for 4 or 5 months, and we had gone on walks, we had held hands, we had kissed, and a week prior to this, we had sexual contact. We were very intimate. We had a nice time, and then the day before she says this happened, we also were intimate. And then on the night in question that we were intimate, we had an argument afterward about where our relationship was going. We would not be able to advance that evidence to challenge the complainant's narrative about a platonic relationship unless we succeed at this application. And what is trying to be said by many is that's not relevant at all.
I was just thinking about, my favorite judge, JC, Justice Pachauko from the Ontario Court of Appeal. I don't know, it seems sometimes that almost every case I cite is from Justice Pachauko.
Look, he's
so
an
clear.
Excellent judge.
He's so clear
and
in the way he writes his decisions. And he actually addressed some of a lot of these issues in a case called JC, and one of the things he talks about is common sense and whether or not common sense is permitted to be used. I really like the way he expressed it. He says, to be clear, there is no bar on relying on common sense or human experience to identify inferences that arise about the evidence. Were that the case, circumstantial evidence would not be admissible, since by definition, the relevance of circumstantial evidence depends on using human experience as a bridge between the evidence and the inference drawn. And he also makes the point that the concern is not whether you're using common sense or whether evidence, in another section he talks about evidence that could be used for an improper purpose.
And I think that's something to highlight.
Yeah, but he says it must be grounded in the evidence in that particular case. So it must be grounded in evidence about the way that person, behaves, or what that person says about their own emotions or feelings.
And how is that relevant
just like
to the
in these
tribal
applications, we go through statements that were made and we ground our application in statements made by the complainant so that it's not just some free-floating bare assertion. It's grounded.
Right. And so really one of the apt comments by Justice Pacheco is that evidence is not barred because it could lead to myth-based reasoning.
Right. So here's that paragraph. He says,
this is really important, again, for the 900th time we've mentioned throughout podcasts.
The second critical point in understanding the rule against stereotypical inferences. Stereotypical inferences. So in this case, like Crown quite often will say, I'm concerned about this evidence they want because it could be used for this improper purpose.
It could be used, and it's barred because it could be used.
And so they seek to have it barred because it could be used.
Stop.
That way.
Pause.
Right.
That's an argument we face often. And if, I'm curious to see what our viewers who are lawyers in other jurisdictions say about their jurisdictions. But the argument they actually say this without laughing, that this evidence is inadmissible because it could be used and does raise myth-based reasoning. Not that it will. And here, here's the joke. I've heard this on applications. I know Mr. Neuberger's reputation. I'm not trying to jerk myself here. I know his reputation and is a skilled cross-examiner. He would never intentionally do that. But it has the potential to raise myth-based reasoning.
And there's a reason why we don't want it to be misused.
We certainly don't, but that's not a bar. Justice Pacheco has said clearly, just because it can raise that doesn't mean it's automatically inadmissible. In fact, it can be admissible if it's grounded in the evidence and relevant.
So he says the second critical point in understanding the rule against stereotypical inferences is that this rule prohibits certain inferences from being drawn. It does not prohibit the admission or use of certain kinds of evidence. And then he cites a really great article written called Myth, Inference, and Evidence in Sexual Assault Trials to further make that point. So just because evidence could be misused, that's why we actually make closing submissions and give guidance on what the evidence was. And also in our applications, we lay out all of what's known about stereotypes and when it's a stereotype, what inferences can be drawn, because we don't want judges to make a decision where they've misapplied, our intentions with the evidence, because then it puts at jeopardy an acquittal.
Just think about this for a second. We're in an application and a trial, and we're seeking to admit evidence that we strongly suggest is highly relevant to our defense and to challenge the narrative of the complainant. The argument against it is that it could raise, inadvertently, myth-based reasoning, and therefore it should not be allowed. When we're saying we're not going to allow it to be used that way, we will be very careful to ensure that in our submissions that will be in writing, that we're never going to rely upon any myth-based reasoning.
Yeah, like we're not going to make a submission. Let's go back to the original thing we were talking about, twin myths. We're not going to make a submission saying, Your Honor, because she had sex with him for a certain number of times, then clearly she's a slut and therefore she must have consented.
Right, but let's not even.
That's the way these.
But with all due respect,
right?
that's far off. This is much more.
That's the way they talk about it in the media, though. They talk like defense lawyers.
Okay, but let's talk about it in court for a moment. We're facing that there could be an argument about a myth that's those are real myths that are just absolutely not applicable. We would never do that in a billion years.
There's a list of myths that I want to go through with you
and
later,
we will.
too. Yeah.
But there's other myths that they're talking about, okay? And we'll cover that for a moment. But just think about this logically for 1 second. We are specifically saying that as part of our case, as part of our submissions, ultimately, we will never make a submission based on the fact of any type of myth. And regardless of our undertaking that could not go to consideration by a judge, it still should not be admissible. Think about that for a moment.
We go to great pains to make sure that all of the potential, inferences that are prohibited are not put into
I know,
play.
but I'm not trying to tout ourselves about this. What I'm trying to get people to think about
I'm
is...
just suggesting that other people should keep that in mind because when I see a case where somebody could have, should have been able to engage in lines of questioning, but they're not permitted to have a retrial because the applications weren't done right, it's upsetting because, again, it's an access to justice problem. And the legislation's so new that people don't understand. And I think, too, one of the deficiency issues is that there's a sort of an ethos where people think, well, I don't want to put my stuff out early, as if you're not going to have to testify in a sexual assault trial. But I don't really know, but it's so important, I really hope that, there becomes a little more coherence on how to do these things and what's expected. And coherence is not something that we got from the JJ decision, as far as I'm concerned.
What I'm trying to just focus on for a second, and your points are extremely well made, and they're apt and they're right. I'm trying to focus on the speciousness of the argument against the admissibility of the evidence.
Yeah.
That, and this is really important, that this evidence, although maybe relevant, should not be admissible because it could possibly lead to a myth-based reasoning for which the defense will not do. Pause. That's a specious, unmeritorious argument that can create incredible mischief with the right to make full answer in defense and can lead to wrongful convictions. That is not an argument that should ever be made. Specifically in the face of any lawyer for the defense, not just us, any lawyer who specifically says, look, here's how it's relevant, here's how I'm going to use it, because that's what we do. We lay it out, and I am telling you, I will not use it for these purposes. Right. And the judge will be instructed on that by us in our submissions. So that argument should never be made against the admission of the evidence. Ground it in something that makes sense, not some hypothetical possible up by a judge down the road. That's not a way to exclude evidence, and that's highly dangerous.
But some of the arguments that we've had sprung on us, and they do literally get sprung, so we don't get responses to the applications until the last minute. And I understand Crown are very busy and overwhelmed. But so some of the arguments that have come up, we've kind of gone, what? And finding the case law to rebut it, I've been running up and down, printing stuff off and bringing it back because we just didn't even expect a certain argument to be made.
Yeah.
And of course now we've heard most of it by now because we've done so many of these.
There's probably going to be something else.
I'm sure there will be. But the interpretation of some, the wording and stuff, this is one of the reasons people hate law so much when they hear lawyers talk about it. It's all about words. You're just arguing about words, not about real people's lives or something. And sometimes it can seem like it. And this one particular thing that comes up a lot in these applications is that they say, and we've just had this, well, I can see that it might be probative, but it's not significantly probative of an issue at trial.
Great point. Can I just close a loop on something? So we were talking about whether this is dead or not, narrative or whatever. So I just want to take Goldfinch for a moment and read this into the podcast. So I just closed a deal on this one. Because we were faced with this argument, and then we're going to move on to your excellent point, because the next stupid thing that's being said to us. So Goldfinch, which is being held up to say that context is dead and narrative dead, says the following, paragraph 63. Evidence of a sexual relationship may also be relevant when the complainant accused have offered inconsistent statements regarding the very existence of the relationship with the accused. So in this case, there was no contradictory statements, but the very existence or the inconsistency between the complainant's version and the accused can give rise to why the context or the narrative of the sexual relationship is relevant. Goldfinch stands for also the proposition that relationship evidence may be relevant to the coherence of the accused narrative and by extension credibility. There will be circumstances in which context will be relevant to the jury to properly understand and assess the evidence. That assessment, however, must be free of twin myth reasoning. General arguments that sexual nature of relationship relevant to context, narrative, or credibility will not suffice. Right, bare assertions will not suffice. This is so important. This is Goldfinch itself.
Mm-hmm. And a lot of these issues that we're talking about too, I think in this case that, like we mentioned, I'm really concerned about, it's called TWW, just came out of the British Columbia Court of Appeal. There was a dissenting judge on the Court of Appeal, so that gives them a right to appeal to the Supreme Court. And a lot of these issues are mentioned in the dissent. So
let's get there in one sec. But just the Goldfinch gives instruction. The majority gives instruction. In fact, they were all in the majority. So the accused application to survive scrutiny will have to follow through as follows. To satisfy the relevance requirement, the accused must demonstrate that the evidence goes to a legitimate aspect of his defense as integral to his ability to make full answer in defense. This requires the accused to be able to identify specific facts or issues relating to his defense that can be properly understood and resolved by the trier of fact only if reference is made to the sexual activity in question. In articulating these facts or issues, simply citing the need for greater context or fuller narrative is not enough. We have said that, and that goes back in time to Seaboyer and other cases. Nobody has ever argued with this. Goldfinch is nothing new. Ben's calling me. Goldfinch, that's my son. Goldfinch is nothing new. There's nothing new about this. This does not mean that context and narrative is dead. It does not mean that. It didn't change the law. It maybe simply clarified some issues, but it did not end that line of evidence. Any argument to the contrary is wrong. Now,
it was mostly urging people. There was a trilogy of decisions, Barton, Goldfinch, and RV, that all came out back to back at the beginning of 2019. And they were really just urging the courts to be more cautious about the way they handled 276 applications.
Great. Needed a reminder. Right. I'm all about reminders. Now, you raised an issue when you cut you off, which I want you to talk about is, so how relevant does this have to be? Right. It has to be significantly probative. What the does that mean? Because they want you to believe that it's like trying to get over the 75% threshold. What does it really mean, Diana?
So the phrasing is along the lines of, because I think now with the new legislation, there's two different versions and two different sections. But anyways, the general phrasing is the evidence must have significant probative value that is not outweighed by its prejudicial effect. So in translation, probative value means it will tend to prove a material issue, not some frivolous sort of side thing, right? But it's going to go to an actual live issue to do with narrative and context and credibility and so on. And that it has some ability to assist with determining the truth or the likelihood of one version being more true than the other.
Good.
That's probative value.
Well explained.
Prejudicial effect means that there's some sort of damage done to somebody's reputation that's not necessarily justifiable or to their dignity and privacy. So dignity and privacy are the main focus of the, and why complainants have representation by counsel now. So we're seeing quite often that they take that word significant and say, like in this latest one, well, I can see it, it has some probative value, but it's not significant. Therefore, you shouldn't be allowed to use the evidence.
Significant. It must be significant.
So in JJ that said this legislation is
recent Supreme Court of Canada case.
Yeah, just came out within the last month or so. They cite a case called Derrick, which I also have, which we mentioned earlier, which said the legislation's constitutional, which JJ says it's constitutional.
Right.
This court found that the phrase significant probative value in the 276 context, that's the sexual, prior sexual history applications, simply requires that the evidence not be so trifling as to be incapable in the context of all the evidence of raising a reasonable doubt.
Repeat that again slowly.
And the most important part is the beginning, that the evidence is not so trifling, right? So they're saying the word significant just means it's not trifling. And the interpretation of that is so important, because if they didn't interpret it that way, then it would violate constitutional rights of the accused.
Then the entire regime would be unconstitutional.
Right. Because
does everybody understand that? If it was to be such a high threshold that the argument often by the Crown or a complainant's lawyer is, this legislation would be utterly unconstitutional. In order to remain constitutional.
To make
The
full
threshold.
answer in defense.
The threshold for evidence to be admissible, in other words, to be significant, really mean. And this is when courts and lawyers around with words that are really frustrating. But it requires the evidence not be so trifling as to be incapable in the context of all of the evidence of raising a reasonable doubt, which means it just has to be kind of relevant.
Yeah, and when you go to Derek, to the paragraph that they're citing, which is paragraph 39, they go even further to say that it must be interpreted to mean that it was not necessary for the appellant, the accused, to demonstrate strong and compelling reasons for admission of the evidence. That is not required. And yet the word significant is now being presented as being, well, we have to prove. It's a reverse onus, because all of the evidence is, and this is an important phrase too, presumptively inadmissible unless you meet a certain threshold. But the problem is the threshold to be constitutional must be actually quite low. It can't be trifling, and although we have to show it has some relevance, we don't have to make a strong and compelling case, because it's not the trial. And you hear me yell that when I'm reading these responses all the time. That's a trial issue. This is not the trial.
Right. They seek to screen it out. And here, and let's be fair now. So the balance to the privacy interests and the integrity of a complainant is that the balance will be, and the court does this, is that this non-trifling evidence, should not be substantially outweighed by the risk of prejudice. So in other words...
And also substantially outweighed.
Substantially outweighed. So the court has to do a balance. There's evidence that is relevant, and it's non-trifling. So it has significance, right? It's not we use the word dispositive. It's not going to solve the case. It's not the smoking gun. It's evidence that can raise an inference to support the defense and contradict something of the complainant. And we got to see, does this evidence substantially harm the complainant's privacy or integrity? And most of the time it doesn't, because of the probative nature of this evidence. And if you're careful and calculated and smart about the way you look at your evidence, because you don't want to screw up your trial in any event, you're going to put your best foot forward and show why it's relevant and it's going to be admissible. Mm-hmm. This is the threshold. This is the standard.
Another thing I liked from JJ was they actually said, I don't have the paragraph in front of me, but they actually make a point to say that part of the reason it's constitutional is that when you're looking at the risk of prejudice to a complainant's dignity or comfort, they said mere discomfort will not be enough. That it actually has to, be a significant violation in that balancing equation.
You're absolutely correct. Now, you know what? We're getting close to running long on this, and I apologize. But you raised something earlier, which I think we have to look at, is there is a never-ending list of f***ing myths that they're trying to create in the courts. Like, it's a myth that
women lie about rape.
Yeah, and it's
which would what?
It's dangerous, and it's a myth that an accused should ever. If there's a complaint of sexual assault, an accused, it's a myth that the accused would deny that actually occurred.
Right.
In other words, because one of your defenses could be, we never had sex.
That's actually from a case, but.
No, really?
This idea too, the idea that it's a myth that women lie about rape would mean that if you plead not guilty, you're engaging in a rape myth. Right? So you're shut down already. That's
by pleading not
stereotypes.
Guilty.
So
if you take it to its extreme insanity, right?
Yeah. So there was a list, and it's in Seaboyer, right?
Yeah.
Yeah, it's a little bit further to I can't remember. I was originally looking. They only have page numbers at a certain point, but I did. Yeah, I started highlighting them. There's a list of things that are rape myths, and some of them we agree with, right? So the twin myths.
A lot of them we agree with.
The twin myths are included in there. There's a thing called the doctrine of recent complaint, which is this idea that if somebody doesn't make a complaint right away, then they're less credible or they're lying. So we understand there's lots of reasons that people won't report right away. But there were three that really upset me. And this is a list. In it, it's not the majority decision, but it's a partially concurring decision written by Justice Leroux Debay, where she says she's citing an academic and she gives this list of things that are myths. And so the three that upset me kind of came near the end. And that's because two of them...
Do you want to look at this for a second?
Yeah, two of them are actually motives to fabricate. So near the end, they say, women as fickle and full of spite. Another stereotype is that the feminine character is especially filled with malice. Woman is seen as fickle and seeking revenge on past lovers. So, and we've actually seen this called a rape myth, that to say that somebody is a spurned lover.
It's happening right now in an application that will be heard later this month, where the Crown is arguing that a motive to fabricate because the person was a spurned lover is a myth.
Right. And, but it does happen. It doesn't, to think that it happens, that's always why somebody is making an allegation. So that would be fallacious.
This is again denying human behavior. And why people do the shit they do. Why people lie, why people make up stories, why people want to hurt each other. Why? And we see it in family court all the fucking time. So for the Crown Attorney to actually argue that women are incapable of making a false allegation because they would be spurned of a man is just bullshit. And you have a study here that we can reference, and which we can just do it quick. We're going to have to come back.
Motives for filing false allegations of rape, but
it's an actual study that's peer reviewed and reliable and validated.
Yeah, and but we had a great analogy as we were going through this thing and talking about these. We're saying, okay, well, there's a reason why people say barns are red. It's because there's quite a few red barns.
There are.
But just because there's quite a few red barns doesn't mean all barns are going to be red.
Drive through northern Ontario or rural Ontario, or the breadbasket of our province. Take a look at how many barns are red or some shade of brown or green. Okay, not all are green, not all are red, or not all are brown. Just like not all men will lie, not all women will lie.
But there is a reason.
But some people do, and some barns are red.
And there's a good reason why most of the time people think of a barn, they think of a red barn.
Right. And even in Seaboyer, it specifically spoke about, and in Osselin and others, that you cannot deny the building blocks of a defense, which may include a motive to fabricate. Motive to fabricate is not a fucking myth. Motive to fabricate is a legitimate aspect of a criminal defense to an allegation. Because people make shit up because they're angry at somebody else.
Motive to fabricate is always seen as an extremely probative area of cross-examination.
But what we're facing now is that there's an argument that it's actually a myth that a woman, there's no such thing as a spurned lover who will lie for a particular reason.
So the next one,
are you kidding me?
The next one is also motive related. So
why are we doing this?
And this is from case law. This is from Supreme Court. It says the female under surveillance is the victim trying to escape punishment, and goes on to say it is assumed that a female's sexual behavior, depending on her age, is being surveilled by her parents or her husband, or more generally, people of the community. Thus, the defense argues if a woman says she was raped, it must be because she consented to sex that she was not supposed to have. She got caught, and now she wants to get back into the good graces of whoever surveillance she was under. So this is a crazy way. This is a crazy way of saying what?
Doctor, was it Mr. Carter? Mr. Carter, can I say something, Mr. Carter? For those of you who are as old as I am, you'll remember what show that's from. I had a trial. Okay? Just bear with me, please. I'm sorry. This is a long time ago when the law was normal. And the complainant was married. The accused was married. They went to a casino. He gave her money to gamble. They gambled together. They had a really good time. They went back to a hotel. They had sex. On the way back, the f***ing husband of the complainant met them, accused her of cheating on him, and she said, I was raped. Right. Okay? And said, the whole time I was with him, he kidnapped me. I was completely unhappy. I didn't want to be with him. He was forcing me to do everything. It was awful. And guess what? Her husband took her back, and we went to trial. And guess what I was able to get? And Grace at our office was able to assist in going through hours of surveillance camera footage from the f***ing casino. They gave it to us. God bless, because back that day, if we wrote to them, they actually gave us shit, okay? Mm-hmm. Now they go, no, I have to give it to the police, which we'll never go get it. So we got several hours of footage from the casino, broke it down into segments, screenshot, everything. This was it was probably one of the most satisfying cross-examinations. Can I just have 4 minutes for this? So this complainant asked to testify behind a screen. So I denied it. I said, I'm not agreeing. Police officer who was in charge testified and said, no, she's very scared. This will allow for her to tell the truth. And I asked one question. Your officer, Do you believe the complainant? Absolutely, I do. Have you ever met a complainant you never believed? No, I haven't. Do you believe in any way, shape, or form that testifying behind a screen will help the complainant lie? No, that's absolutely not true, Mr. Neuberger. Okay? So then the officer sat beside me, and I got to cross-examine. I didn't turn over the surveillance until about a week before. Nobody read it. Nobody looked at it. Nobody did anything. I turned it over. I didn't have to back then. Okay? There were video of the complainant with my client at the poker table kissing him, stroking his neck, touching him, kissing him. As he won a pot of money, he gave her $1,000. And we're going back like a period of time. They're going to the cash out room. She's kissing him and touching him and stroking him, and he's giving her money, and they're holding hands, and they're making out. Okay? And screen after screen, I stilled it on a big camera. And I went by, so was this you hating it? Was this you not wanting to go near him? Was this you not liking it? Sorry, did you not like the $2,000 he gave you at that point? She was dead. Dead. And I remember turning to the officer during my cross-examination. Well, you've met an innocent accused now, officer.
Right.
They withdrew. But this is a stark example. And we do not get cases where it's going to be on continuous surveillance. This is like a rarity.
So this is called, just to remind people, this is supposed to be a rape myth.
Yes, that's a rape myth. That a woman would make up a lie to cover her tracks for cheating.
It is called alibi, and it is in this paper, peer-reviewed paper, the number one reason that people who admit they lied have said that they lied about it was for an alibi for one reason. It could be because they got caught cheating, or it could be because they failed an exam, or a bunch of other things. But alibi is number one reason. And so then the other one that you
unbelievable
that you mentioned as being, and this goes to the core of an actual defense, and will be the thing we end on, is apparently a rape myth, disputing that sex even occurred. Right? Disputing that sex occurred. That females fantasize rape is another common stereotype. Females are assumed to make up stories that sex occurred when in fact nothing happened. Similarly, women are thought to fabricate the sexual activity not as part of a fantasy life, but out of spite. So it starts out sounding like, okay, this sounds like something you're like, yeah, rape fantasies or whatever. Some people might engage in that, but that's not common. And it shouldn't be a stereotype. But what comes afterwards is more important. Assuming that women make up stories that sex occurred when in fact nothing happened, and that they're doing it not as a fantasy but out of spite. So that means that if somebody says, if their defense is not, no, she consented, yeah, sex happened but she consented, but if their defense is, as we've had cases before, there was no sex, that apparently is a rape myth.
Can you just repeat that one more time so everybody understands this? Because it defies logic and human nature and, God forbid I say this, common sense.
So, it also assumes that if there was an opportunity for sex, that a guy would engage in it. So therefore, women...
How many times have we faced that cross-examination of her client?
No.
You mean to tell me you were in a bedroom with her and you guys were lying down and sex wasn't on your mind?
Mm-hmm. She's only wearing blah, 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 blah. There's another thing, too, is I remember, hearing somebody say, oh, I heard that there's not a single sexual assault case where women aren't asked what they were wearing. That is so sick. And I was like, of course they're asked what they were wearing, so we need to know how the clothes got off.
Great, but have I ever, in the years you've watched and been assisting me and working with me collaboratively in all these cases...
The choice of clothing.
Have I ever asked about the choice of clothing?
No. It's only important if it's something that's really complicated to get off, or if it's something,
It goes to the unfolding of the events.
Some what they're wearing.
Right, but they can wear whatever they want.
I know.
They can have whatever preferences they want. But that has nothing to do with veracity or non-veracity.
No matter how sexy the lingerie, sometimes the guy actually didn't have sex with them.
Right. Yeah, it's the male. It's the myths.
Defense.
It's the myths about male sexual aggression, and we've had the ability to get there. But the myths that they want to try and have codified in law now is that that a man who would say against this allegation, we didn't have sex. I don't know what the she's talking about. Mm-hmm. That would be a myth. That would be a lie.
And it's not just saying it wasn't me, like an identity issue. They're saying, no, I was there. We went out. There was no sex.
Fabricating an allegation of sexual assault.
That's a rape myth. How dare you not have sex with that woman?
Fabricating an allegation of sexual assault because you're pissed off against this guy because he ghosted you. and fucking made you feel humiliated, and you look back on it and think, well, this wasn't consensual. Yeah, that's a fucking myth. No, that's not a myth. It's reality. Yeah. Or God forbid, you're in the context of a high conflict divorce, and an allegation of sexual assault's made up so you can get fucking sole custody of the children and fuck them all the way through the family court system. No, these are all fucking myths. And if we go down that road, we're all dead.
Yeah, I know, because pleading not guilty actually makes you guilty of a rape.
No, but we're dead because there will be no way for us to engage in human relations and have trust. I fear for those who come after us, that they have to live in this world of creativity that these people dream up about human relations.
Well, the expectations on the way people behave sexually has to match actual human behavior as well. So there's an actual drive to get legislation in place and to change the way people actually interact with each other, so that you need to get, and this gets back to the carefulness of the wording that's required in these cases, that you're actually going to require verbal consent before you can do anything. But even if you got verbal consent, as we've seen in some other cases, judges won't believe you. They'd be like, yeah, nobody actually behaves.
We're in another topic now. But I think, sort of the sum up of this is that we're going to an absurd length, and we're meeting these in applications. I think it angered us enough to actually go back and review this case law. And the reality is the case law that's come out is somewhat complex and not that helpful in some respects, but really it's just a reminder of principles we've had in place for over 2 decades. Mm-hmm. So there's nothing new here.
We cannot undermine our legal system with the goal, as we are kind of hearing, with the goal of increasing convictions and getting more justice for assumed victims.
And if this application process now under 276 and 278 is used as a bar to admitting relevant evidence, it's highly probative. Then it is a roadmap for wrongful convictions, as noted by the dissenting judges in JJ. Exactly. Until next time, and more rants, on behalf of Not on Record, thank you for listening and watching.
Like, subscribe, hit notifications, leave comments. We do actually read them.
But you know what? Please, we've got people from other jurisdictions. Give us your comments. I love reading about what's going on in your jurisdictions.
It's fascinating.
It's really great. Thank you. And thank you very much, everybody.
Good night.